you will be, of course, confronted by 52, which incorporates that total procedure into Young Offender Act process. His Honor has asked me to briefly comment that Section 33 of this Act is, if you take a look at it, is kind of an oddball section. And from a bail point of view, it's particularly confusing as to what may take place. And I'll let you find it for a second. I'm almost out of it. That's the section that deals with the failure to comply with really a probation or a disposition in some way, a willful failure to comply. There's apparently great consternation in judicial circles at this time as to whether that's a separate charge or in the nature of kind of a revocation proceeding of the original order. And I think my humble opinion is that it's clearly a separate process because there's an information laid, and therefore I would see it as a separate process, and that the bail would apply to it, and you could be held in custody on that type of breach. However, there are those, and perhaps some of them out there in the audience right now, including Stanley, who would be very happy to have it found to be not a separate charge, but merely a continuation of the original disposition and an allegation of a revocation of that original disposition with an attempt to have the judge rehear it. And if that's the case, then there are no provisions for dealing with a detention or a bail on that type of allegation. And there would be no available bail hearing at all for that, because it would not be in the nature of a separate charge. And if that's the case, of course, people can revoke at will and not be subject to any consequence until the finding of revocation is made. And I've been asked to point that out. I would certainly, from a Crown perspective, argue very strenuously that that is a totally separate charge, just as a breach of probation is. And he can be brought in and we can have a bail hearing on it. And that's not only good sense and good legislation, but it's good in policy, and that's the way it should be interpreted. So that's basically, I think, what you're going to be facing on judicial interim release and some of the problems that I see with it.
Thank you, Brian. I might just add a couple of things. The second interpretation of Section 33, that it's not a separate offense, but rather a continuation of the first one, was the position taken by Judge Nevins in Newmarket in one of the very few, I don't think it's a written decision, but one of the few decisions we know about under the new Act. And he held that there was no power to detain in a failure to comply proceeding, charge, whatever it is. It is important to note that breach of probation charges are no longer available. They're specifically exempted under the Act. Secondly, Section 7.5, which talks about that those persons who may authorize detention, that's not really relevant to this province. That was designed to legitimize a procedure in Quebec that's been in place for some time of an administrative, where there's an administrative body that reviews possible detention decisions and makes the possible detention decisions prior to coming before the court. And as I understand it, there's no intention to create that body or make use of that section in this province. And thirdly, and I can only speak for Toronto, as I understand it, justices of the peace are available and are hearing these matters on a first appearance basis during the night, during the week, and on weekends. And some judges have been volunteering to consider themselves available at least on long weekends for appearances on Saturdays or Sundays. So there are judicial interim release hearings taking place, particularly on weekends, and a number of decisions to release, as I understand it, being made on weekends, generally by JPs, and on long weekends, in some cases, by judges who are making themselves available for those hearings, just so that you know that. Now that completes the area of judicial interim release. Stanley Avruskin will now deal with notice and age.
Thank you very much. The area of notice and age is quite well covered in the material you've got, in material prepared by Ms. Ferns and Mr. Pearson. And for the purpose of this short period of time, I will just touch on the highlights of those areas. They are in the index located at the beginning of the book, and in relation to age is about halfway through the book. Except to say that notice and age were popular, are popular, and I frankly hope they will continue to be popular areas for innovative defense counsel, or simply we obstructionists in the course of administration of justice. The issue, just to jump ahead, has never really, I don't think, been resolved in the YOA as to the effect of the absence of one or the other, although I'll speak to that at a later stage. Notice will be dealt with firstly, and under the Young Offenders Act, it is found in Section 9 of the Young Offenders Act. It's set out through some 10 or 11 subsections, and unhappily, there really is no logical sequence to the laying out of the subsections. But when you read them, or read them later today, or this evening, or perhaps on the weekend, as I'm sure you all will do, assuming you have a legal aid certificate, please bear in mind the effect, if I can just jump away from my topic for a moment, of Section 3 of the YOA dealing with fundamental principles. It's my view, and of course I've got no judicial authority for stating it, but I'm going to state it anyway, that these principles on which the Young Offenders Act was legislated apply to almost every important issue of a hearing. Whether the hearing is the first appearance, the bail hearing, the responsible adult hearing or not, or even the trial, and that is that among other things, there are some 6 or 7 principles there which will be the subject matter of other discussions later today. But one of them, I think, is quite important, and that is that a young offender is entitled and has a right to have the least possible interference with his freedom. And if a sloppily served notice to a parent, or there is some doubt about the notice, either as to its form, its content, its timeliness, or what it says, or when it's used, it seems to me that one could argue, based upon Section 3, that notice is alive and well, and if you look at Section 3 about least possible interference, that ought to create a further doubt in the mind of the trier of the fact or law, and that that notice then should be strictly dealt with. And where there's some doubt about it in the Act, or where there is some silence about what it means, I think that the emphasis ought then to shift to Section 3 and say, well, all right, if there has been a failure for complete or strict compliance with the notice, or even the issue of age, that bearing in mind those fundamental principles, he ought to get the benefit of it. And if it's a bail hearing, he ought to have his release. If it's a trial, he ought to be acquitted. And so I think that if you look at Section 3 and look to those various principles, and bearing in mind the areas of doubt or non-clarity in notice and age, there's room for a lot of fun. Also, of course, Section 51 in the YOA, which has been alluded to already, that the criminal code applies so long as it's not inconsistent with the Act, means that the YOA is a more particular legislation and ought to be given that emphasis. Well, notice under the JDA, as well as age, of course, since the 2nd of April 1984, do not have the same meaning, in the sense that they are now allegedly separately dealt with under the YOA. But looking at notice and just looking at age very briefly, again, it's my view that the emphasis, the shift of emphasis, is really on the manner of proof of the notice, and certainly the manner of proof of age is apparently easier for the prosecution. But again, I submit that there is still some room for a lot of discussion. The basic proposition in Section 9 of the Young Offenders Act in relation to notice is, as I read all of the sections, is that notice is still alive and well and functioning, and that notice must be given. And then with typical administrative clarity, if you look at Section 9, subsection 8, it says failure to give it does not affect the validity of the proceedings. And I hope no one has the nerve to ask me what that means, because I must confess I don't know. The material supplied would appear to state that that relates to custodial young offenders. I don't know if that view will be supported later on or not, but if it says in sub 8, subject to subsection 9, failure to give notice in accordance with this section does not affect the validity of proceedings under this act. Well, subsection 9 relates to the released accused or the released while young offenders prior to their appearance in trial, so that if you deduct, it might be said that it relates to custodial cases. Now, that seems odd to me, because certainly custodial cases, by the nature of their custody, and I use custody in a general sense, whether it's pre-bail or after bail and in custody, it seems to me that a custodial situation is one where the charge would obviously be more serious, or the young offender is a more seriously dedicated criminal, and therefore the whole subject matter ought to be of more importance than one who is released. And yet it seems that if you take that view, a released person, there is, if you look at sub 9 of that section, a released young offender where there is a problem with the service might use the failure to his benefit. And it just seems to me the emphasis is on the wrong area of concern. Now, I may be incorrect, but there is room for argument there. The material seems to indicate that a person who is in custody where there is no notice given, or the notice has failed in some way, gets the further disadvantage that the notice cannot come to his salvation. And Ms. Ferns and Mr. Pearson seem to indicate in the article on notice in that area that the notice is not important, because after all, the person's in custody, and it's obviously an important case, and if it's important, let's deal with it without getting around to undue technicality. Am I right, Barb? In any event, whether I'm right or not, there is an argument there. Subsection 9, if you read it, appears to relate to released accused who are released on a summons, an appearance notice, a recognizance, or a promise to appear. And in those situations, the subsection seems to say that if failure is given, that is, if notice has not been given and there's a failed notice situation, the subsequent proceedings are invalid. So up to that point, it's the same as sub 8, immediately above it. But then it comes in and says, unless the parent attends court with the young person or notice has been dispensed with by some way. So there is a kind of a salvation, in my view, for something probably not warranting it. Now that section is being used by some crowns in Toronto and accepted, I believe, by some judges to indicate that the notice to a parent or to whomever should be proven at the very earliest opportunity, and I'll look to that in a few minutes as well. Now, if an accused is arrested or detained, subsection 9, subsection 1 of that notice provision states that a notice shall be given verbally or in writing. So if an accused person or a young person is arrested and detained, I take it detained there means actually detained, whether it's in the police cell for those terrible few hours before he gets to a more graceful observation home with a warrant, or thereafter, notice shall be served. So there it's mandatory. And it may be given in one of two ways, orally or in writing. As I read it, that's the only place where there is an option by the officer in charge at the time to give a variation of the notice, either orally or in writing. And he must state, at least at that time, that the notice of the arrest states the place of detention and the reason for the arrest. In a later section in section 9, that notice must contain certain other things as well. So there's an option there as to notice being given orally or in writing and as soon as possible. Now, from a defense point of view, I think there's room there for further fun and ingenuity, and that is that how does an officer prove to the court, if indeed it is his option or his obligation to prove it, that it's been given orally? Obviously, he'd get in the witness stand and say so, and if it's an important and it's mandatory in Section 9, he may be running a risk if he certainly doesn't at least make a note in his book as to what he's alleged to have said to the parent or to the person receiving the notice. I would think and I would hope that if he can, he would simply pull out one drawer of his desk and pull out a Form 1 or a Form 3 as to the notice and give it to him in writing, and obviously keep a copy for himself so that he'd be able to demonstrate that he's given the notice to a parent who might attend the station as soon as possible. Now, the question, of course, is what does as soon as possible mean? There is an issue that can be raised later on as well as to timeliness of the service. If a person is arrested on day 1 and the written notice which is later given to a parent is dated, say, 2 days later, is that as soon as possible, assuming the parent was at the station at the time of the arrest, but the officer never got around to giving it to the parent until 2 days later? There is no answer to that at the moment. I would suggest that all those cases in relation to timeliness of service of notices, for example, under the drug cases, McFarland's book on drugs has a chapter in relation to service of certificates, which might be useful as to timeliness or even as to content. And it seems to me there is an area there for a defense in relation to notice. Then the section says, after dealing with notice in several different ways, several different modes, and what it means that if you don't serve it, that it now conveniently says in certain areas that it can be dispensed with. So there are provisions made for the dispensing with the notice to the parent, and that is found in Section 9, subsection 5, and the second way of dispensing is Section 9, subsection 10 of the Young Offenders Act. The first area of dispensing or varying with the notice of subsection 5 is where there is doubt as to whom the notice is to be given. So it really is a specific subsection dealing with what I call substitutional service, or the object of the service. It doesn't deal, as I read it, with the manner of the service, which is really subsection 10, but deals with the person to be served. If an officer has difficulty finding a parent, an adult relative, or an adult who is not a relative, or a spouse of an accused, if there is one, and he doesn't know what to do, obviously, or he doesn't know who to serve, it would seem to me that that subsection would click into operation by the application of a motion for directions in relation to who it is that should be served. Now, whether that application is done by an officer without notice to the accused, or with notice to the accused, or with notice to the duty counsel, or with notice to a lawyer at a later time, or what kind of notice, or what material to be supplied, all is silent in the Young Offenders Act. I would hope, though, that because the criminal code is specifically referred to as the starting point, and then dropping back to those principles under Section 3, it would seem to me that the principles of natural justice at least would dictate that there's got to be some kind of service, and certainly upon the accused person, so that he can make up his mind, or he can retain a duty counsel, even at that early stage, to represent him on that application. The second way of dispensing or varying the service of the notice is under subsection 10 of the Young Offenders Act, which deals with failure to give notice. And I take that to be the wider question of complete failure, either as to service of a person or as to the failure of the form of the notice in some way. And there, an application can be made to the youth court judge or justice, as could the prior application. And the first result of the application would be to adjourn the proceedings on certain terms, which terms might well be the correction of the failures alluded to, or if they are so paramount or the circumstances so warranted that that presiding officer, a judge or a justice of the peace, could dispense with the service completely. He can dispense with the notice where, in his opinion, having regard to the circumstances, the notice can be dispensed with. A beautiful piece of legislation. And I thank Mr. Kaplan, or whoever. But it seems to me, again, that it's the typical circular route where if nothing is available, then something is created. Now, it appears to me that notice, then, is quite important, in that if it spends some 8 or 10 subsections dealing with it and then has to do with dispensing it and then varying it, I don't think it could be argued that notice itself as an issue is deceased and buried. Now, dealing with the timeliness of the notice for a moment, both subsection 1 and subsection 2 of section 9, which deals with what I call custodial accused and released accused, both those subsections deal with the service as soon as possible. And again, I indicated that there is a question. What does that mean? Does it mean that at the first court appearance, where the accused, suppose, is released under sub 2, he comes back to court with his counsel or with a mother or with no one, and he's there to set a date for his trial? Does that mean that at that time, the Crown or the judge or someone takes the step of proving the notice? And if so, for what purpose would that proof be launched? Would it be simply to acquire jurisdiction for that day's appearance, for that moment's appearance, or is it designed to last up until the end of the trial completely? What about if there is an accused having a lawyer at that time, and he's there on that set date? The Crown turns to the lawyer for the accused and says, well, do you admit service of the notice on the parent? And after you bite your tongue, when you want to tell the Crown what you would like to say, you say to the Crown, well, I'll admit for the purpose of setting the date only. Can that be done? Is that possible? Is that an admission that could be used only on those strictest terms? Well, if the criminal code applies, there is a section someplace in the criminal code that says you can admit certain facts on consent. It would seem to me that you should be allowed to make that admission for the day or for a specific purpose. That way you can keep your options open. Because if you take the case where there's the 2-day delay in service and you acknowledge service, you may be deprived of the right of making a jurisdictional argument at the trial if the service is acknowledged then and there without some qualifying words. If, of course, you say, no, I'm not going to admit service, then, of course, the Crown will treat you very politely by holding it to the bottom of the list and taking your note, noting your address and home telephone number. 10 minutes left, okay. Now, is that, and if the Crown does that, is that wrong from the point of view of the Crown? Is that the Crown's obligation under the Young Offenders Act? Dropping back to the JDA, it seemed to me that certainly notice was a procedural matter that had to be spoken to by the Crown. And in the absence of anything in the YOA as to whose obligation it is, and with the inclusion again that it's a criminal code matter, it seems to me that it's part of the prosecution's obligation to prove the notice, if not then, certainly at the trial, and certainly early in the trial. I have invited certain Crowns to take the view that, oh, don't bother with notice today, let's just set the date and we'll do it at a later time. And I've also indicated that I would acknowledge service of a notice and even age if asked for the purpose of setting the date only, and make it quite clear for the record it's only for that day, knowing that you're going to attack them on both grounds at a later time. And I haven't had the trial yet, so I don't know if that's going to be a good idea or not. Now, as to the manner of service on a parent or other, it's again my view, for what it's worth, that under the Young Offenders Act there seems to be a hierarchy of persons to be served. Maybe I'm making things too complicated. There may be others among us today who simply says, look, it's quite all, it's an alternative kind of service. If one isn't available, grab the other, and we don't care who we start with. But it seems to me, again, if you look back at the Section 3, and the very bottom subsection, I think it is, of that section, that parents, subsection H, parents have the responsibility for the care and supervision of their children. And then it talks about removal. Well, I would argue that that's some indication that parents ought to be considered firstly. And if you look at Section 9, subsection 1 and 2, it talks about parents, although parents is defined as being a person in charge, if not the actual parent. But I would argue that the parents ought to be looked at first. If they are not available to be found, then it is open simply to serve the notice on an adult relative under subsection 3 of Section 9. So it's parents first, it's adult relative secondly, but only then if they're known to the young person and likely to assist. And in their absence, it's to any other adult if known to the young person and likely to assist. Now, whether that might be wide enough to include a prior lawyer acting for the accused person, or perhaps a Crown attorney, take your client home with you for the weekend. I suppose the Crown could be excluded because the Crown might not, quote, likely to assist. But there's a built-in problem in that section, again, as I see it, and that is that the likelihood of the assistance and the knowledge of the young person is to be determined by the person giving the notice. Well, who normally would give the notice but a police officer? So here we have an act that expressly incorporates the opinion of a police officer as to the likelihood of an adult to assist. And also he then makes a subjective analysis of the young person about his knowledge of the adult person. And suppose he took a look at the adult person and he doesn't have a three-piece suit on, but is wearing jeans and has just come back from work and is looking kind of dirty. And who knows, maybe he's got a past criminal conviction for some offense. Can he refuse? Even though he has a likelihood to assist and the young person knows him. Can he use his own discretion to say, well, I'm not going to allow that adult to be the object of a service. I'll go and I'll seek a variation. Again, I don't know the answer to that question, but again, there's an area there of some thought at a future time. Okay, then the Act speaks of the marriage. That is, if a young offender is married, perhaps a fourth object of service could be the married person. Then in just a couple of minutes left in relation to age, as my second topic, second part of my topic. The age seems to be in section 57 of the YOA deals with the manner of proof. Again, manner of proof seems to be under the hearsay rules. It seems to allow in all kinds of hearsay evidence to prove age. And you may have the testimony of a parent, so that it's wider. It includes a mother as well as a father. An alternate way would be a birth certificate or a baptismal certificate. So those of us who are not baptized would have a better chance of getting acquitted. Again, it's my view that if you look at all of those subsections, there appears to be an order of proof. You must try the direct evidence first. That is he or she under the age of presently 16? If that fails, then perhaps the Crown, as under the old JDA, would call upon evidence to prove is he or she apparently or appearing to be under the age of 16. Again, there are questions there which have never been solved as to what the lack of the age means. Again, it's my view that the case law would still govern in that situation, that it goes at least to jurisdiction, or if you wanted to have a trial lasting a day or so and there's still failure to prove age, then it would go to the lack of an essential ingredient in the offense. Well, those are some matters then that I'd ask you all to look at, and don't lose your faith. There's still lots of room for fun and games in the young offenders court. Thank you.
Thank you. Just two things I might add about this issue. It seems to me that with respect to notice, the major issue is obviously going to be the meaning of subsections 8, 9, and 10 of Section 9. The two kinds of problems that I can see arising in the short term, for example, on the notice issue, is if a parent shows up at first appearance and that parent's presence is noted, and then that parent is not there when the trial later occurs, has one complied with the notice section because subsection 9A has been met, a parent of the young person against whom proceedings are held attends court with the young person. In other words, the parent then attend for the trial for the notice issue no longer to be an issue? And I think that's one that's going to come up fairly soon. The second issue, I think, ties into the question of how active a role, if any, the court should be playing in these proceedings. Does subsection 10, which talks about the court being able to dispense with notice, alter the ordinary passive role of the court of waiting to see whether the Crown proves age? Or, as with the Juvenile Delinquents Act, is the court to not adopt any kind of active role unless invited to dispense with age, and it's up to the Crown to prove age as part of its case. And where that will arise, I assume relatively soon, is when the Crown closes its case without having proved age. And the question is then going to be raised, can the court at that point start dispensing with notice, adjourning the proceedings so that notice can be given, and so on? And I think that's going to be a major issue to be decided in the next very short term. And I leave that one with you to raise at the appropriate time. I think we have managed, as all expert panels do, given the time, to fill all the time and a little more that's been given to us this morning. So unless there are major questions at this point, I will draw proceedings to a close. Are there major issues people wish to raise? Having chilled you into silence, I would like to then... Oh, sorry. Go ahead. Wait. Oh, should we stop? Brian would have one quick thing he would like to raise.
Just one quick thing. If we called the criminal code the Old Offenders Act, I could see proving age, but we don't bring in an adult offender and call somebody to say he's over 16. And I don't see any reason why we should be fooling around under the Young Offenders Act after all the benefits he's had of the right to counsel and notice and so forth, to start proving age rather than inferring it right off the bat. We don't do it with a criminal offense, with an adult. Why do it with a juvenile or a young offender?
What's in the act for?
On your behalf and mine, I'd like to thank our panel.